Hi, I want to welcome everyone back to the Bulletin. My name is Charina Garcia, and I'm the Strategy and Innovation Partner here at WR Immigration. Today, I have with me Charlie Oppenheim and also Ceri Koski. So, Charlie, would you like to introduce yourself?
Sure. I am Charlie Oppenheim. I was Chief of Immigrant Visa Control for the U.S. Department of State for 23 years. I was responsible for managing the Visa Bulletin, deciding how many applicants could come in each year. I am now since retiring, I became Director of Visa Consulting at WR Immigration.
And Ceri, welcome to WR.
Thanks, Charina. I'm Ceri Koski. I'm a partner here at WR. I've been in the field of business immigration since 2001, starting as a paralegal. And then I started as an attorney in New York City in 2006 and recently joined WR. It's a pleasure to be here. And I'm excited to be here with Charlie. I actually got to co-present with Charlie about 10 years ago at an American Immigration Lawyers Association conference in the Washington, D.C. area. So this is a fun reunion for me.
Oh, great. Charlie is always ever so popular. But very well known in the industry. And we're lucky to have him here at WR. Today, we're going to do our first special deep dive episode of the Bulletin. We're going to talk specifically about the U.S. immigration pathway via what we call the Schedule A. In particular, we're going to talk about nurses and hospitals and organizations and how they can pursue green card sponsorship for their nurses. Before we jump into our discussion, if it's your first time listening to the Bulletin, Charlie and I release episodes together every Tuesday morning on YouTube and Spotify, and soon also on Apple Podcasts and other popular platforms. If you like this episode, you'll consider subscribing to the podcast on Spotify or subscribing to WR Immigration on YouTube. I also recommend listeners follow WR Immigration on LinkedIn for updates on the show, along with lots of other good stuff coming out from our colleagues here at WR Immigration. Please reach out and connect with myself, Charlie, and Ceri on LinkedIn. Also, feel free to send us questions you might have on anything you hear us talk about today. You can also send feedback, questions, or suggestions for topics that you'd like to hear us discuss in future episodes in the link in the description. And with that, Ceri, why don't we talk a little bit about Schedule A and help us understand what is Schedule A and what's the genesis of Schedule A?
Sure. Yeah. So, I think the U.S. economy is feeling it right now. We need workers, and we've always needed workers in this country, and immigrants have always contributed to that need. And, way back in 1965, the U.S. Department of Labor recognized this need and actually created a list of occupations, and they called it Schedule A. So these occupations are designated as being in need of people to fill these jobs. And when it was first introduced, actually in 1965, nurses were a part of that list, and they have always been a part of that list. The list has changed over the decades, but we still have an intense need for nurses in this country. And so today we're really going to focus on Schedule A nurses and the green card process for them.
Okay, great. Yeah, and I'm very familiar with Schedule A because I am from the Philippines, and there are a lot of nurses that come from the Philippines. So we'll focus a lot of our discussion on the Philippine nurses and the impact on the Visa Bulletin on them with Charlie. So with that being said, although there's a special expedited pathway, how does the Visa Bulletin impact the Schedule A process? Charlie?
The Schedule A comes under the Employment Third Preference category. So it's important for people to be monitoring Chart A of the Visa Bulletin to see what the final action dates are. They will govern visa availability in the current month or the upcoming month when the Visa Bulletin's released early. And so that indicates when somebody could either file for adjustment or have their case finalized overseas. The Chart B in the Visa Bulletin reflects the application filing dates. And those are the dates where the State Department expects the Chart A final action dates to be in approximately 8 to 12 months. So you can use Chart B to kind of see where your case may fall in the intervening time.
Okay. And then what we want to do is explore some of the trends for the Schedule A nurses over the years. So, Ceri, can you just kind of give us a history of what you saw when you were observing the visa bulletin? Then we could get some of Charlie's comments on that.
Yeah, absolutely. So my practice has included Schedule A nurse cases. And during a really, really intense period where it was like a free-for-all, because in 2020 or at the end of 2019, and into 2020, Schedule A EB3 became current. And it was actually current from October of 2020 until May of 2023. And so during that time, probably, thousands and thousands of Schedule A nurse I-140 petitions, immigrant petitions were filed. And it was a very, very productive time for hospitals, healthcare organizations, recruiters to get nurses into the country and to fulfill this labor need. And, the labor need is still there. Although many thousands of nurses were able to come in and partially answer that labor demand, there's still an intense need. And, perhaps Charlie can provide, more context around the fact that even though these are Schedule A cases, they're still EB3 and they're still subject to the backlog. For example, right now, cases are current as of September 8th of 2022. So there's about a 16, 17 month wait for that party date to come current.
So, Charlie, can you talk a little bit about why it became current? So it was backlogged in October of 2019. And then it became current in 2020, 2021, and then 2022. And then 2023, we saw a retrogression.
Yeah. For the past several years, the employment annual limits have been artificially high. And the reason for that is family-sponsored number use at overseas posts was extremely low because of post closures during the COVID times. Therefore, the annual limits in employment were greatly increased. The fiscal 2022 limit was double what the normal limit would be, and that allowed the categories to go current because it was the State Department and USCIS wanted to maximize number use under the annual limit for the employment third preference applicants, and making it current gave the best chance of using all of the numbers. For fiscal 2024, we're returning to more normal levels of employment limits. They're still relatively high, and they're going to decline again for fiscal 2025. So we're coming back into kind of reality and can expect the third preference date to fall behind the actual calendar date. And I would expect the third preference date to remain behind the calendar date, and the distance may begin to increase.
But I think what we'll see is that it'll just return back to perhaps the 2019 dates, right? That many employers were accustomed to, in terms of, instead of the visa bulletin being current for EB3 Schedule A, it'll just return back to the 2019 kind of numbers. Is that right?
Right. I think you're absolutely correct. I'm hoping that the EB3 category can, stay within 1 to 2 years of the actual calendar date.
Okay. And then, Ceri, as we walk through a Schedule A, and you had noted before, there's no need to test the labor market, right? So the Department of Labor has already determined that these are shortage occupations. So what do you need to prepare in order to file a Schedule A?
Yeah, that's a great question. And I think that your point that there's no labor certification requirement does really cut down on the time needed to prepare and file these. If employers have prevailing wage determinations and notice of filings that they keep current, meaning that they're filing prevailing wages maybe semi-annually or quarterly, then they can keep the occupations and locations, because I think it's really important just to note that in Schedule A, you have a specific occupation, typically like a registered nurse, with the same minimum requirements, and we all know that there are certain certifications that nurses need. And a designated wage as per that location. So as long as employers keep prevailing wage determinations current, and also there's a 10-day business day notice of filing that has to be posted, if they keep those two items current, then they should be able to file Schedule A cases on a rolling basis, which will partially answer the demand. And I think it's worth noting that, again, for this next month's visa bulletin in March of this year, the current party date for EB3 worldwide, including the Philippines, is September 8th of 2022. So, if healthcare organizations with their recruiters are working with us outside counsel to file these cases, the delay is not substantial, but it's still a really great idea to have those quote unquote multi-use prevailing wage determinations and an everlasting notice of filing to be ready when candidates are identified, so that these cases can be filed very quickly.
And what do the nurses need in order to file an I-140? What sort of documentation do you need from the nurse?
So that's a great question. So with EB3, we do these for either skilled workers or bachelor's degree professionals. So registered nurses really just need certification that they're able to perform as a registered nurse in this state in which they will work, where the offered position is, and or an NCLEX certification. And so, recruiters, we would recommend working with candidates to make sure that they have this documentation, because that documentation needs to be filed along with the I-140. So collating that documentation is really important up front. On the back end, there is a language test, a pre-visa language test. Charina, you and I were talking about that a few weeks ago. That has to be done before the immigrant visa appointment. So it's not something that has to be done in advance, but it definitely should be planned for.
Okay, and that's the visa screen certificate that they have to present when they go in for their visa interview if they're doing consular processing, correct?
Right, the visa screen. So the sequencing of events is important. The visa screen is done probably these days 6 to 12 months after the Schedule A case is filed with USCIS, to align when and before the immigrant visa interview.
Okay. And then I know that there's premium processing option for the I-140. When have you used premium processing, or when have you recommended the usage of premium processing? Because there is an additional fee of, now it's $2,805, I believe, and it's 15 business days for premium processing.
Right. So premium processing is a fantastic tool to incentivize the recruiting of employees and nurse candidates. And, it was widely used in 2021. I remember the summer of 2021 when we were filing hundreds of cases per week. And employers were using premium processing as an additional incentive to onboard nurses, because the party date was current and those nurses could get into the United States sometime in 3 to 6 months. These days, because of the retrogression and because the party date is current as of September 2022. There's really no need to premium process because it's not going to expedite the immigrant visa interview. So employers really don't have to pay that additional fee. Practically speaking, there's no incentive because of that September 8th, 2022 priority date.
Okay, so once the I-140 is approved, Charlie, the file gets transferred to the National Visa Center, right? And so it's the date that the I-140 was filed that determines the priority date for the nurse, right?
Correct. The priority date is the date on which immigrant status was acquired.
Okay, so once the file is sent to the National Visa Center, I've heard that some nurses are getting processed in terms of, the next steps, the fee bills and all that other stuff, while some nurses are getting a letter saying that your case is on hold, your date isn't current. So can you kind of explain that to us?
Yeah, and I've heard that, and I'm a little puzzled where two applicants with exactly the same date would get different letters. In theory, the National Visa Center should notify all applicants who have a priority date earlier than the applicable application filing date and request that they begin submitting the required documentation. So for now, the third preference application filing date for third preference is February 1st of 2023. So anybody with a priority date earlier than that should have been notified by NVC to begin assembling and submitting any required documentation.
So if I file an I-140 for a nurse in last month, in January of 2024, and the chart B says February 1, 2023, and I premium process, what I should be receiving from the NVC is a letter saying that my case is being held because my date is not current under chart B. Is that right?
Correct. And the reason chart B is used is they want to have the applicants submitting the documentation so that they can become documentarily complete. And the State Department then has visibility into the amount of demand, which allows them to advance the final action date at a reasonable pace. And then once the applicant's priority date is within the newly announced final action date, they would immediately be scheduled for final action and an interview at an overseas post.
But in reality, let's say I got a notice that said my case was held, whereas my friend got a notice saying, okay, start gathering your documents. At the end of the day, the consulate can't actually issue me the visa or schedule an appointment until it's closer to when the priority date will become current, right? So the issuance of the hold letter or the issuance of a start gathering your documents letter, at the end of the day, the result seems to be the same.
Pretty much. The problem is the reason they use the application filing dates is they want those applicants to submit the documents because they'll be processed in a reasonable amount of time. They do not want applicants to go through the time and expense of assembling any time-sensitive documentation, which may have been expired by the time their turn comes up and require extra processing. So,
yeah, just like the police certificates, right? Because the police certificates are only valid for, is it a year now or 2 years? I can't remember anymore post-COVID.
Exactly. And at one time, there were more time-sensitive issues involved. But again, an interview cannot be scheduled for final action until the applicant's priority date is within the applicable final action date.
So, for example, if right now, what is the final action date for Schedule A?
September 8th of 2022 for March.
So September 8th, 2022. So if I'm a nurse and I have a priority date of September 5, 2022, and I finished all my document gathering, my case has been completed by NVC, and I'm waiting for interview. at what point does NBC actually start scheduling the interview? Like, do they know in advance that it'll be current in March? So will they schedule me in March, or will they schedule me before March?
Well, what would have happened at the beginning of February, NBC would have reported to the visa office all the applicants who have a documentarily complete case. Everything's received, ready to go. Only those applicants would be then eligible for a potential March appointment based on the newly announced March dates. That's why it's very important for applicants to act in a very timely manner when assembling and submitting their document, because you want to be in line and ready to go once the date moves.
So once the date moves, and let's say, okay, I have everything I need, and Department of State knows that I'm documentarily qualified, and they're scheduling my appointment at the U.S. Embassy or consulate, whether it's Manila or whatever consulate it is, will I be scheduled in March, or will I be scheduled in April?
Say that you had been included in the report received February 1st or an earlier report, then, and you were within it, you would have been scheduled for an appointment at some point during March. If you submitted your documents, say today, then you would not be being scheduled for an appointment potentially until April.
And how much lead time does the consulate usually give you for your appointment? Because you still have to do your medical exam, all of that. So what's the typical lead time that they give you to appear for an appointment?
Ideally, they would give several weeks. Normally, the appointment letters would start going out in the middle of the current month for appointments scheduled in the upcoming month.
And what I would always tell my clients, because you can't schedule that medical appointment because it's going to be after the interview, I tell them to just go to the interview, right? And then the case is just pending approval or immigrant visa issuance until they get that medical report from the doctor. So that's typically what I tell them. Do you do the same, Ceri?
Yeah, I mean, if they don't have time to pull everything together, it's worth going to the interview when it's scheduled rather than trying to reschedule it, because it's a gamble to try and reschedule an appointment. And of course, with the designated medical examiners, they're going to get the results to the consular post as soon as that medical exam is completed.
Yeah, and Charlie, are we giving the right advice? Or is that aligned with what we should be?
In an ideal world, you would have everything that's required when you appear for the interview, but many applicants do not. The key thing is, though, if a person is refused because they don't have a medical or they don't have another document, is return and overcome that refusal during the month of original interview, if at all possible. You do not want to risk having to be rescheduled for a subsequent month when the final action date may have retrogressed. And also, whenever the National Visa Center schedules an appointment, say if they schedule me for an appointment in Manila for March 4th, Manila has a visa number for me. So if I walk in the door, there is a number available for me. And in theory, that number would remain available for me throughout the month of, March. So I would want to return and get my visa. Whereas somebody that had been refused, say back in January, and shows up in March, there may or may not be a visa number available for them.
So submitting your documents timely, like booking the earliest medical appointment you can, and then making sure all your documentation is complete, is really important for your interview.
Yeah. And normally you could figure, when you've submitted the last of all the required documents, the earliest you would be scheduled for an interview is typically about 2 months after that occurs.
Okay. And then, of course, with our nurses, they also need the visa screen certificate, right, Ceri? So that's extremely important. They have to have that when they appear for the interview. Otherwise, their immigrant visa won't be issued.
Yeah, and that's where I think recruiters can come in, and if they're helping to onboard these nurses and remind nurses and prepare the applicants for the interview in advance.
Yeah. And I think also, for practicing for over 25 years, sometimes I'm pleasantly surprised by the visa bulletin. So even though we may say, oh, there's like a 14, 15 month, 2-year wait, sometimes you're pleasantly surprised by certain things that happen, right, in Congress. So Charlie, you want to talk a little bit about the Real ID Act of 2005 and how that really helped the Schedule A nurses?
Sure. Back in the early 2000s, there was, as there is now, there was a severe nursing shortage. And so various groups were lobbying Congress saying, we need more nurses, do something for us. So in the Real ID Act of 2005, Congress recaptured 50,000 unused employment numbers and made them available for Schedule A workers until they were all 50,000 were used up. And that provided a great benefit for the nurses. They basically got 2 chances at an immigrant visa number each month. First, under the normal employment third preference limit, which would have a final action date established. And then a different date would be established for the Schedule A workers, which would be often months later than the other date. So you would have 2 chances. So it was a tremendous benefit at that time, and it greatly enhanced the nurses and the availability of nurses during that time. All 50,000 numbers were used up by approximately February of 2007.
So it took 2 years to use up all the numbers?
2 years, because these cases were being scheduled alongside all other immigrant visa cases. So although there were 50,000 numbers, they had to be kind of folded in with the normal post-capacity workload. So it took some time, and it took a little time for applicants to become documentarily complete. But like I said, it was a great benefit.
Okay. And then what have you heard today about lobbying efforts that hospitals or healthcare organizations are trying to do to bring back the Real ID Act of 2005 or some version of it?
I haven't heard. There's been some interest and some efforts, but I haven't heard anything really going forward very far in terms of any action. With recapturing numbers, that can only be done through legislative action. There are plenty of numbers which would be available for recapture in the employment categories if Congress were to decide to do so, saying that, this is in the national interest to allow more Schedule A workers, especially after the issues that we faced during COVID times when there was so much stress put on the nursing profession, and we saw how much more nurses were required at that time. So there could be action. I typically don't see much legislative action happening in an election year, though. So I think that any productive action would occur after the presidential election, although there may be some rumblings now, and any rumblings would be basically so people could get an idea, is there real interest that we could push this type of bill forward?
Okay. So we'll just have to see, and time will tell what happens. But for now, our EB3 Schedule A nurses, the final action date for March of 2024 is September 8, 2022. Philippines is not carved out from there, right? Philippines is still part of rest of world, correct, Charlie?
Yes, right now, and for the past several years, Philippines has been at the rest of world third preference date. I think it will, for the coming months, it will remain there. But I think maybe sometime toward the end of the fiscal year that the Philippines third preference date may start to fall slightly behind the rest of world date. At this point, I don't think it would fall more than 1 or 2 months behind the rest of world date if that were to occur.
And I think that what people need to know is it may fall behind a little bit, but it will probably come back in October, right? So it's not going to be a huge impact usually or delay.
I think we will have to wait and see. One of the things the State Department normally on their website publishes a report of the annual waiting list at the National Visa Center as of November 1st of each year. They have not published the November 1st of 2023 data. I would be very interested in seeing what the Philippines total is for employment third preference. That would allow me to give a better projection whether the Philippines third date will remain behind worldwide going into fiscal 2025 or, where it will stand.
So basically Philippines would only be carved out if it hits its per country annual limit.
Correct. The beauty of what the Philippines is, the Philippines primarily uses numbers in the employment third preference category. And the way the employment preferences are set up is that any unused numbers from Philippines employment fourth or fifth can fall up to Philippines first preference. Any unused employment first preference numbers fall to second, and in the second preferences numbers then fall to third. In recent years, that has always allowed the significant portion of the overall Philippine limit to fall and be made available for use in the employment third preference category. I would say probably 70% of the Philippine limit at least is used in employment third, which is a tremendous benefit. And again, that would be beneficial going forward in helping it stay closer to the rest of world date.
Okay. So, Ceri, as you hear all of these things that Charlie's talking about, what are some tips or advice you can give to some of your, the healthcare organizations out there, the recruiters that are trying to bring in nurses to the U.S.? I've heard that you can, if a nurse has an approved I-140, they can keep their place in line. So can you tell us a little bit about that?
Yeah, thanks, Charina. And I think Charlie's point about EB3 Philippines being 70% of their usage is really important. I mean, that's great that the unused employment-based preference categories can feed back into that EB3 for nurses. It's really, I think, an important point. So yeah, if a nurse has a Schedule A I-140 approved, and they're waiting, and let's say, potentially they get another offer or there's another opportunity out there with the different healthcare organization, they can actually use that priority date with a new employer. So, if they've had personal circumstances, maybe some family issues that prevented them from using that first I-140, a second employer can do a Schedule A for them, and that party date's actually locked in. So they can get to the U.S. and assume that new role very, very quickly as soon as that Schedule A is approved. That's the great thing about priority dates, is that they're retained.
Great. And so, just want to wrap up here. So, Ceri, any final thoughts or advice on the topic of Schedule A?
Yeah, I mean, in connection with, the labor need in general, the Congressional Budget Office actually just came out with some new data and indicated that by 2042, immigrants will really be the source of all U.S. population growth. And so, the need for immigrants to fill the demand for employment in the United States is just going to increase. And so EB3 Schedule A is a fantastic opportunity and option for nurses.
And Charlie, any parting thoughts or words of advice as well for you?
The only thing I can say is, since it was already done back in 2005, when numbers were recaptured specifically for Schedule A nurses, given the shortage we now face and the fact that there are probably well over 100,000 employment numbers which would be available for recapture. I think that provides a glimmer of hope if there could be some type of lobbying efforts to get something done there.
Great. So thank you both for joining me. Just some housekeeping things. These episodes are released every Tuesday morning on YouTube and Spotify, and soon also on Apple Podcasts and other popular platforms. I hope if you like this episode, you'll consider subscribing to the podcast on Spotify or subscribing to WR Immigration on YouTube. I also recommend listeners follow WR Immigration on LinkedIn for updates on the show, along with lots of other good stuff coming out from my colleagues here at WR Immigration. Please reach out and connect with myself, Charlie, and Ceri on LinkedIn, and feel free to send us questions or topics you'd like us to address via direct message. And of course, you can always send feedback, questions, or suggestions for topics that you'd like to hear us discuss in future episodes in the link in the description. And again, just to close it out, thank you, Ceri and Charlie, and bye, everyone. See you next time.
Thanks.
Thank you.
Take care.